Outside Lake 3 versus Jonathan Henderson.
Welcome back to another courtroom breakdown. Today's docket isn't about one dramatic criminal trial. It's a series of real landlord-tenant disputes, where every hearing could determine whether someone keeps a roof over their head or loses it. Presiding over these cases is Judge Simpson, and while many of the legal issues appear straightforward on paper, the human stories behind them are anything but. You'll see tenants facing financial hardship, attorneys negotiating last-minute agreements, and a judge balancing compassion with the limits of the law. But one case later in this session will stand out from all the rest. A heartbreaking misunderstanding involving a grieving mother that leaves the courtroom wrestling with whether justice and fairness always lead to the same outcome. Stay with us, because this hearing builds toward one of the most emotional housing cases you'll see.
Anything for the plaintiff?
Hello.
Mr. Allen.
Your name? Your name?
Jonathan Henderson.
All right. And how much do we have owed?
307,731. We have a consent.
That's right. Okay, and he's going to get this paid by the 6th. Okay. Sir, you signed this consent judgment?
I did.
All right. You have any questions regarding its terms?
So if the payment is not made by the 6th, I wasn't aware that there were other options. I just kind of signed the first thing that was given to me, unfortunately. But if the payment's not made by the 6th, what are the other? I mean, what will happen?
Well, what this judgment indicates is that you're going to pay it by the 6th.
Yes. I'm just curious.
Well, the only other option would be to move on these terms.
Okay. I'm not, like I said,
No, I got you, but
yeah.
Are you not going to have it? I mean, what?
I mean, right now I'm making steps to get it, but it's all like, I was listening to the young lady's testimony prior to this, and I'm kind of slightly on the same boat with that situation. I'm on long-term disability.
Is Miss Herrera?
Yes.
I'm
on long-term.
Yeah, but there may be. I don't
slightly.
think you're in that boat.
Like I said, slightly. I'm just talking about in relation to just how I get paid. I get paid lately by long-term disability. That's been kind of held up for the last 2 months, and it wasn't. Hopefully, I remedied the problem today. It was just a situation of paperwork. But no, I just want that to be on record.
Okay.
So it is kind of based on last time it took a week for everything to come through. I have some things in play, hopefully. So that was all.
All right. Did you wish for me to sign this judgment, sir?
Not particularly, no.
So what do you want me to do?
Well, what were my other
Because
options?
you're not disputing the amount.
Oh, I'm not
So-
disputing the amount. I owe the money. It's just about what will my options be in terms of if you can do an adjournment until I've heard dates like 13.
I'm not, on this case, I'm not going to do an adjournment. It's obvious that you have the.
May I have just a moment?
Yeah.
It's like, so you're not going to have it next week.
I mean, at this point, I'm just going with, like I said, I'm just trying to take care of the situation as best I can.
You did it. I'm sorry, sir. That doesn't tell me anything. Can you have it by the 10th?
Oh, yes, I can have it by the 10th.
May I?
All right. That's fine. So the judge, if it indicates that you need to pay it by the 10th, do you have any other questions regarding?
No, I understand. I was just, if I could get more time, it would just be appreciated. That's
And Mr. Fink explained to you your rights under the court rule regarding 3-day rescission.
Not particularly. Oh, yes. In terms of if I'm not happy with this, yes, I did. He explained it.
But as the court can see, he's thrilled.
Yes. All right. I will enter the judgment by consent. All right. Thank you, sir.
Thank you.
This opening case is a perfect example of how a consent judgment works. The tenant never denied owing the money. Instead, he hoped for a little more time because disability payments had been delayed. Judge Simpson focused on one key issue. If both parties already agreed to the terms, the court's job isn't to renegotiate them without a compelling legal reason. It's a reminder that signing a legal agreement has real consequences, even when unexpected financial problems arise afterward. These situations can feel harsh, but courts also depend on certainty so that both landlords and tenants know exactly where they stand moving forward.
Outside Lake versus Natasha Olmos.
Same thing for the plaintiff. The claim is $2,125.57.
I'm sorry, how much was that?
The total is 2125.57.
Under not being here, judgment to the plaintiff, that is by default for possession. Redemption amount, any amount requested with a writ issue.
Thank you.
Avalon Housing versus Militia Tate.
Good afternoon, Your Honor. Jill Bauer here on behalf of Ms. Tate.
And I have a dismissal that what the parties are doing.
Yes, Your Honor.
So I believe you.
All right. Case is dismissed.
Thank you.
All right, thank you. Hamilton Crossing versus Jessica Harrison. Your name?
Jessica Harris.
Thank you.
The claim is $8,024. Ms. Harrison, we had filed on her either last year or earlier
This year.
this year. And either last year or earlier this year, there was a bankruptcy stay. She had a discharge. Since the date of the discharge, her balance is 8024.
And ma'am, how are you intending on getting that?
Oh, and I'm moving.
Pardon?
I'm sorry.
It's okay.
I don't feel good. And I should be gone by next Monday.
So you're gonna leave?
Mhm.
Okay.
I
So
just
here-
came because the amount that they gave me was inaccurate. They were trying to charge me for rent before the bankruptcy. And my attorney said that they can't do that. They can't charge me for the rent that I wrote off in bankruptcy.
I thought Mr. Fitz, you said it was since bankruptcy.
We've reduced that since.
Yeah. Okay.
So what is the amount?
8,024.
Okay, and I plan on making payment arrangements. This is what I discussed with Ms.
Yes, you
Yakita
can,
or
but what
Yakisha.
you can talk to them about making payment arrangements. I'm gonna find no tribal issue in this case after hearing judgment to the plaintiff for possession.
Notice how the conversation suddenly shifts away from emotion and back to legal procedure. Jessica Harrison raises concerns about repairs she says she paid for herself, but Judge Simpson explains why this hearing isn't designed to decide those claims. The court is only determining possession of the property, not every dispute between landlord and tenant. That's an important distinction many people don't realize until they're already standing before a judge. If you were in her position, would you expect those repair costs to be considered in the same hearing, or should they require an entirely separate legal case?
Now, I do have a question though.
Yes, ma'am.
What about the repairs I had to pay because they have not been making any repairs? I haven't had a closet since October.
Well, ma'am, this is for possession of the premises. So my understanding is you said you're leaving.
Mhm.
Okay.
But I had to pay someone to make the repairs that they have not been making.
Okay, then what I would suggest is that as you look at this amount here as to what you will owe, that you work that out with the landlord in terms of.
Okay.
All right, okay. The no travel issue, rent they fixed. Thank you.
And that just means that the police come on the 6th, or what does that mean?
What it means is they can file for an order for the court to issue that you would be forcibly removed from the premises if you have not moved.
Okay. I just need time to clean it and I'm not feeling well.
I get you. Okay, thank you.
Thank you.
Court calls the case of Hamilton Crossing 2 versus Trevon Weatherspoon.
I think Ms. Bauer is going to pop up on that one.
Yes, Your Honor. Jill Bauer here on behalf of Ms. Weatherspoon, who is also present.
All right. Oh, there she is. Okay, she needs to. Ms. Weatherspoon, you have to be stationary, otherwise I gotta pass your case. She's still driving. I'm calling her while she's driving. I'm not gonna discuss the case. Ms. Weatherspoon, you need to pull over.
Yeah, I'm having a feeling of deja vu with somebody driving in your courtroom.
So am I, which bad things happen when that occurs. So I'll pass it. You call her, see if we can get this taken care of. Court does call the case of
Okay.
Hamilton Crossing 2 versus Tiffany Roots. Okay, there she is.
The atmosphere changes once again as another tenant steps before the court, but this time there appears to be an opportunity to avoid eviction entirely. Instead of immediately arguing over unpaid rent, both sides begin discussing a structured payment plan that could allow the tenant to stay in her home. These conditional agreements often become the last lifeline before an eviction moves forward. Whether that opportunity succeeds depends entirely on following every condition exactly as written, because even one missed payment can reopen the case almost immediately.
All right, what is the claim in this case?
Claim is $2,261, but I have prepared a conditional order of dismissal I don't know that she's seen it, but it requires her to pay the 2261 in 5 equal payments of 376.33 and a final payment of 376.85 starting October 15th and going through March 15th of next year, and to pay her rent timely starting October 1st. This case will be dismissed. The requirement to pay rent can be enforced for 1 year. If she doesn't comply, we submit an affidavit of non-compliance. Judgment order of eviction with 5 business days for her to object. The 14-day period is waived.
All right. Ms. Roots, does that sound like something you want to do?
There is only one problem with that. I was told that I will have until the 5th to make the payment every month. Not that I'm looking forward to being late, but I don't start. So I did get a job. The job doesn't start until Monday. I was supposed to start last Monday, but they pushed the start date to this Monday. So I will not be, I may not have the entire
Got it, Judge.
October by the 1st. I am driving for Uber, but I'm not really making a lot of money because I have to rent the car in order to drive. So
Gotcha.
what I'm wondering is, is it possible to make a partial
So
payment?
you need to have your rent paid by the 5th as opposed to the 1st of each month.
Yeah, I've changed it to defendant shall pay monthly rent timely and in parentheses, no later than the 5th of each month commencing October 1st, 2025. And I am emailing that to the best court staff we're in front of this afternoon.
Okay, does that work for you then?
That works.
That works. Okay. And you have any questions regarding what the terms of those conditional dismissal would be? Any questions at all?
Is that something that I can read personally and then ask a question?
Go ahead.
Well, I'm here. I can ask the questions. What happens if there comes a time where I can only make a partial payment? Like if the 5th comes of October and I'm only able to make a partial payment, what will happen? Is it just going to go right into?
That means they can reopen the case and file an affidavit saying that's what you did in violation of the agreement. Submit to the court a judgment as well as the order of eviction, but you gave her a 5-day period to object to.
I did.
All right. But there would be a 5-day period where you would be able to say that you object to their reasons for doing what they did.
Okay. That's my only question.
Okay. You have any problem with us entering the conditional order of dismissal?
I do not, no.
Judge Simpson isn't simply approving paperwork here. He makes sure the tenant understands every legal consequence before giving consent. He even explains her right to challenge the agreement within 3 business days if she later realizes she misunderstood something. That extra safeguard is designed to protect people representing themselves in court. But once those deadlines pass, the agreement becomes much harder to undo. Small procedural details like these often determine whether someone keeps their housing or finds themselves back in court weeks later.
All right. If the conditional order of dismissal meets those terms, do you give Mr. Fink permission to sign your name to that?
Yes, I do.
All right. Ma'am, I would advise you, since you're unrepresented by counsel, you had 3 business days to think about it from the time of my signing. If you believe that there's some misunderstanding, some confusion on your part, some legal reason, or some right you didn't assert, you'd have to file a motion with this court within 3 business days. You understand that?
I understand.
Okay, very good. I will mark this file as conditionally dismissed. Ma'am, have a great weekend.
You too, thank you.
Thank you, Your Honor.
Front Vista versus Tisha Clark. Oh, he's doing that. Ma'am, what's your name?
Tisha Clark.
Yeah, we may have the COD worked out, but I need to check my email real quickly.
All right, very good.
She's been working her way through the terms of the COD. She's already made 3 payments on time, which made her eligible for a rental reduction, and it looks like her arrearage is 841, and she will make those payments in how many equal monthly payments? 6.
Hey, yeah, I mean, if it's like, sure, but I mean, I probably could pay it before that.
So if you're comfortable, her arrearage is 841. We're going to do a COD that requires her to pay rent on time for a period and to pay that 841 in a period that she and the landlord will agree to. And if you are comfortable with those terms, and she is, if you advisor of MCR 4.201J, we'll hammer this out next week and submit the order with her signature and ours.
All right. Ma'am, would you be acceptable to that?
Yeah.
Okay. And I would indicate that you would have 3 business days from the time of my signing of the conditional order dismissal to, if you believe that there is some mistake, some right you didn't assert, some confusion on your part, you'd have to file a motion with the court within that time frame. Doesn't mean I'd set it aside, but you have that right to do that. You
Okay.
understand that?
Okay.
You have any questions whatsoever?
No.
All right. So we'll get her signature on it. I'll mark this file COD. I'll expect it next week. You have a wonderful weekend.
Okay.
In your honor, for the record,
Yes.
Miss Tisha Clark is pretty awesome.
Thank you.
So noted. All right. You take care.
You too.
Up to this point, most of these hearings have followed a familiar pattern: payment plans, consent agreements, and straightforward possession rulings. But everything is about to change. The next case doesn't revolve around someone refusing to pay rent. Instead, it raises a much more difficult question. What happens when someone believes they're following the rules, only to discover they've accidentally surrendered the very rights they were trying to protect? This next hearing quickly becomes the emotional centerpiece of today's docket.
I'll recall the case of Hamilton Crossing 2 versus Weatherspoon.
Thank you, Your Honor. Jill Bauer from Legal Services here on behalf of Ms. Weatherspoon, who is also here and now part.
All right. Very good. Thank you. All right. What are we doing on this case?
Well,
Go ahead.
this is an unusual case in my experience, Your Honor. So Ms. Weatherspoon, we obtained 2 sources of rental assistance for her, and her balance was paid in full, but she still owed September rent, and she talked to the office about doing a payment plan and had terms of a payment plan that we thought we were all in agreement with. And today, while I was Miss Inget and I were trying to get the terms of the COD in writing so that we could submit it to the court, I was told that Ms. Weatherspoon had moved out and surrendered her keys on September 19th. So I talked to Ms. Weatherspoon about this, and my understanding of what happened is Ms. Weatherspoon's partner was murdered in July. The people that are being investigated for killing him some of them live in Hamilton Crossing, or associates of them live in Hamilton Crossing. They've been harassing her. She's felt very unsafe. She has young children. So she went to the office to ask to be moved, and she was presented with a VAWA form to fill out, which she submitted along with a police report about the harassment. And she agreed to surrender her keys on the 19th. Now, she didn't know that this meant she was giving up her rights to her housing. She thought this was a process that she had to comply with to be moved to a new place. And so she was she did turn in her keys and she did sign that paperwork, but she did not understand the repercussions of doing so. And unfortunately, I didn't find out about this until today. I think she viewed it as separate from the non-payment of rent case and thought that she had handled it properly herself. So as we sit here today, she did present a payment plan. She owes September rent. She had a acceptable payment plan to catch that up by mid-October, as well as pay October rent by the end of the month. But now she's possibly homeless with small children who are, still lost their father this summer, and it's just kind of tragedy and trauma on the family if that's the result of this process.
This is where the courtroom shifts from discussing paperwork to confronting real human tragedy. According to the attorney, Miss Weatherspoon wasn't simply struggling financially. She had recently lost her partner to homicide, feared for her family's safety, and believed she was following the proper process to obtain safer housing. Those facts don't automatically change the law, but they dramatically change how everyone in the courtroom views the situation. The difficult question becomes whether a genuine misunderstanding can undo actions that have already produced legal consequences.
Mr. Fink.
She turned in a notice to vacate saying she'd be out on the 19th. She put her keys in the drop box. The landlord, with a notice to vacate and the keys, took possession of the unit. It was essentially vacant. I'm not saying it was empty, but from our perspective, possession has been surrendered. The landlord has taken possession, and and reasonably took possession. And it's not an unlawful ejection. And she did also turn in a form under the not under VAWA, but under the statute, asking to be removed, I think, under the state statute. But we have possession of the unit because she surrendered possession.
I don't know, Ms. Bauer, that I can order them to put her back in under these circumstances. I mean, it is kind of strange, but she voluntarily gave up the unit. There was nothing that the landlord did to coerce her or to move her in that direction.
Well, Your Honor, I don't know if you want to speak to her directly, but she thought that she was complying with the process that was necessary to have her rehoused. She did not understand that she was completely giving up. And I would say that my conversations with her did not align with her believing that she was giving up, because she was talking to me about how she was going to catch up her September rent this whole time. So it's, and also it doesn't really meet the VAWA, the conditions of VAWA, but she was given this form by the office to fill out. So I think it was a very confusing situation for her, and there should be some consideration for her confusion.
Well, yes, certainly. I mean, I would have, in looking at it, if she had, say, turned in the keys, but they had not yet taken possession, that might be one thing. That's one thing. I'm not sure that on a possession case, where I've not rendered judgment, but then the tenant has voluntarily surrendered, I don't know how I put her back in, if you're following what I'm saying. I mean, I get it if the landlord had done something during the course of that process, this process, that would lead her to leave or to surrender, but that's not what has transpired here, from what I understand. I mean, the only thing that's leading her to do that is rightfully or wrongfully, but it's not the landlord that's causing the angst.
Judge Simpson's reasoning is becoming much clearer here. He repeatedly acknowledges the heartbreaking circumstances, yet he separates sympathy from legal authority. From his perspective, the landlord didn't force the tenant out, and once possession of the property had already been surrendered, the court's options became extremely limited. That's one of the toughest realities of civil court. Judges can only grant remedies that the law actually permits, even when the outcome feels deeply unfair. What do you think? Should judges have broader authority to reverse situations like this, when someone clearly acted under a misunderstanding?
Your Honor, if I could just say one more thing, Your Honor, I don't think she would have turned in the keys on the 19th if she hadn't believed that that was what she needed to do to be rehoused. And I think that information did come from the landlord, and she's nodding her head yes.
Your Honor, may I think there's no reason not to believe Ms. Bauer when she says her client made a mistake, but yet she surrendered possession. And by the way, Your Honor, I've got some photographs. I'm looking at an empty living room. She surrendered possession. That includes the line that defendant surrendered possession it may be there's some relief for her somewhere in reapplying for a unit or seeking some assistance in finding another unit, but she moved out. My client has possession. I think this case is moot.
Yeah.
Your Honor, if I could just say one more thing. Miss
Sure.
Weatherspoon was homeless when she moved into the unit, so she never had for a lot of furnishings. And she didn't remove the belongings that she had from the unit because she didn't realize that when she turned in the keys that she was essentially surrendering the unit.
Your Honor,
I don't know how that's.
I don't want to
case.
prove the case, but these pictures don't back that up. And I'm not saying anything about Ms. Bauer, and I think she is reporting what she believes to be true, but the photographs don't support that. And I'll
know that there's anything I can do. The issue of possession by her actions has become, and I think that's probably true, that it's now moot. I don't, in this case. I mean, she did the act.
I'll submit an order.
All right. So what I'm going to do is I'm going to dismiss this case, surrender possession of the property.
Thank you, Your Honor.
All right.
This ruling may sound surprising at first, but notice exactly what happened. The case isn't dismissed because everything was resolved happily. It's dismissed because, legally speaking, there is no longer a possession dispute to decide. Judge Simpson concludes that the tenant voluntarily surrendered the property before the court entered judgment, leaving nothing left for him to order regarding possession. It's a painful reminder that timing and legal procedure can completely change the outcome of a case, regardless of how sympathetic the underlying facts may be.
Thank you for listening to us, Your Honor.
All right. Thank you. Huron Vista versus Giovanna Nesbeth. She was on, there she is. All right. What's the claim?
I had put in a money order for $350 inside of the mailbox today.
When did you do
before I went to
that?
my daughter's school. So maybe you haven't got
Today?
an update in regards to that, but
Okay. So what about the rest of it?
okay. So in regards to the whole COD thing, now I had conversations with Machina in regards to when I email, so I can know what to do if I am still able to be a part of the program or not, because I reached out to Sarah as well just to try to help me with $500 so I can get down to the 1623, but I haven't got a response back from them. But if by today's date I don't know anything about the forgiveness plan or anything like that, I need to know.
So
If you
is she
understand what I'm
eligible?
saying.
Yeah, I got you.
She has never gone in to talk about the program. The note that I have is she has not been in to talk about a payment agreement. She said she was going to get help from a church, and it is possible to do an agreement. Your Honor, what I'd like to do is have a judgment, extend the redemption period to the 13th with a note that the parties can submit a COD. Have you give her the terms of MCR 4.201, and that'll give her some incentive to get.
It was kind of fast. I mean, it's in my AirPods, so I kind of hear, like I kind of heard like the MR something 15.
Yeah. Okay. So here's what I'm going to do. You're not disputing the amount that's owed. So I'm going to issue a judgment for possession with that total amount of 2871. So we won't go up because October is right around the corner, right? And
Yes.
I'm going to extend, normally you would have until the 6th of October to pay it, to get into the office. And I'm not going to have any objection if you work out a payment plan or change this into a conditional order of dismissal to allow you to get this paid off.
And that's for the whole 28?
Yes, ma'am.
Okay.
All right, but the object is that you need to get into the office to work out a payment plan that allows you to pay your rent and pay this off. Got it?
Yeah.
So
So I'm not part of the program at all. So I would have to still pay the 1623.
Well, I'm not saying that you're not part of it. I'm saying it's got to be formalized into writing. So you got to get
Okay,
into the office, okay?
okay, that
Okay, and
works.
talk to them and try to work it out.
Okay.
Okay, got that?
Yes, I do.
Oh,
Thank you so much.
okay. After any signing of the conditional order of dismissal, and if you believe that there's some mistake, some right you didn't assert, or some other confusion on your part, you'd have those 3 business days in which to ask the court to set that the conditional order of dismissal aside.
Okay.
Okay, but Ms. Nesbitt,
Yes,
understand, you got to get into that office and work it out, okay?
no problem. I'm about to get ready
All
to head
right.
up there right now.
Today's courtroom session showcased just how different housing cases can be, even when they all involve unpaid rent or possession disputes. We watched Judge Simpson approve negotiated payment agreements, explain important legal protections for self-represented tenants, and issue possession judgments where the law left little room for discretion. Most memorably, we witnessed the heartbreaking Weatherspoon case, where tragedy and misunderstanding collided with strict legal procedure, ultimately leading the judge to dismiss the case after determining the property had already been voluntarily surrendered. Throughout every hearing, the judge emphasized that compassion matters, but so do signed agreements, deadlines, and the legal limits of judicial authority. Cases like these remind us that knowing your rights before making important legal decisions can be just as important as arguing your case in court. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.